we sign a joint will? It's a common question I get from married couples, and let's talk a little bit today about why it's probably not a good idea for you and your spouse to sign a joint will. My name is Andrew Ayers. I'm an estate planning attorney. I've got offices in Edina, Minnesota, and New York City. And today we're going to talk about a pretty common question I get when I first meet with married couples. They've heard about this idea of a joint will, and they're wondering if that's going to be right for them and their estate plan. So we're going to first start with the basic question of, do married couples even need an estate plan? And as an estate planning attorney, you can probably guess my answer to that's going to be yes. Now, your estate plan does not have to be complicated. We're not looking at hundreds of pages of trusts and long wills if that's not what you need. But as a married couple, it is important to consider whether or not you need an estate plan. If you don't have that estate plan, you're leaving it up to your local state's laws, your local rules as to what's going to happen to your assets after you're gone. You're no longer controlling your legacy. You're leaving it up to the court system to decide. And if you're a young married couple in your early 20s, this may not be a lot of concern for you. However, if this is your second or third marriage and you have children from a prior relationship, those state laws may not leave that money where you want it to go if you get married. You may be inadvertently cutting out your own children from your will, or diluting it with the children of your new spouse. So before you just brush it off as something you don't need, especially in a blended family, we want to make sure that we've considered what the law says and whether or not that's really what you'd want your legacy, what you'd want your estate plan to be if you were to die without a will. Now, of course, an estate plan is more than just a will. There's also going to be healthcare documents and powers of attorney. And these are those other documents in the will that it's important to consider. But today we're going to talk and look at what's called a joint will. And so that question is, can you both sign the same document? Now, it's a little concerning if you go online and try to look up the idea of a joint will. You're going to find websites out there that say you can do them, and sure, we'll sell you a form for that. But I'm here to tell you today that's probably not a good idea. First of all, not every state will even allow you to do a joint will. Some states, like Wisconsin, will not admit that will to probate, meaning that the joint will not be able to control your estate if you're in Wisconsin. And the second reason is, if you have a joint will, it can't be changed after one of you dies. So going back to the example of a blended family from about a minute ago, if your spouse dies first, and then you want to remarry later in life, you can't go back and change that joint will. You're stuck with that will, that plan that you created with your now deceased husband or wife. And you're now married to somebody else who likely will not be happy with the way that distribution would go under that will because you were married to them at the time. So when people come to me and ask, should we sign a joint will? My answer is always no. It's probably not a good idea, and we need to look at your situation. What we can do instead is what we call sweetheart wills or mirror wills. And in that case, you and your spouse are signing wills that essentially match each other up. The same provisions all across the will, the same people get the same money, the same children get the same distributions. Everything is the same, but you're each signing your own individual document. As you can see, with the difference between that and a joint will is, of course, if one of you dies first, you're not bound by the terms of a joint will that can't be changed. If you remarry later in life, or if you have more children, you can then make changes to your will so that your estate plan and your legacy is properly planned for. You're not stuck with that joint will that you downloaded from a website back in 2012. It's very common for married couples that I work with to do these sweetheart or mirror wills because their interests are aligned. They have a couple of kids. We're not looking at blended families, so we all know who should be getting what, and it's a simple process to draft up that same document twice, one for you and one for your spouse. Now, one area of the estate plan where things may be a little bit different is going to be with your healthcare documents. So for most married couples, let's say with young children, for your healthcare power of attorney, you want each other to be that person to make those medical decisions. But then the next level down, let's say you're both incapacitated, who's going to make medical decisions for you? Most of my clients will want their own siblings or maybe their parents or somebody in their family be that secondary and third person in their healthcare power of attorney. You don't necessarily want your in-laws to be the person making the healthcare decisions for you if you become sick. So while your wills may mirror each other, your healthcare documents may have a second or third healthcare power of attorney that's different. And that's one of the reasons why we don't necessarily always do joint documents for married couples. If you really want to do a joint document, the common place I see it is in a joint trust. So if we're setting up a marital trust for you and your spouse, and we have reasons to put assets into the trust, and we're going to manage it for your children who are underage, in that case we can do a joint trust that is signed by both of you and has a lot of provisions that specify what's going to happen to your assets and your legacy. It's different than a joint will, and that's where I would recommend a joint document. As you can see from the variety of documents here, a joint will, powers of attorney, a joint trust, these are not something I would trust to a website. Again, when I got ready to shoot this video, I went online, and you can buy joint wills from a variety of websites with no indication that depending where you are, the will might not be valid if it's a joint will. There also were not big cautionary flags, which should be there, that says, by the way, if you both sign this and one of you dies, the other one is stuck with that joint will. So this is a big danger of just trying to buy some forms off of a website. Instead, work with a professional who can look at your situation, your family's legacy. For example, especially if you have that blended family, we want to make sure your estate plan takes care of your children as well as your current spouse and isn't accidentally cutting somebody out because you didn't create an estate plan or you're working off an old will that is from 15 or 20 years ago. So if you're ready to get started and you have questions about the process, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page that'll take you to my calendar for a 15 or 20 minute phone call. We'll go over where you are in the process, what kind of questions you have, and make sure you know the next steps to protect your legacy. Just because you saw something called a joint will on a website doesn't mean it's a good idea for you and your family.